As you hopefully know, legislative intent statements do not equate to a mandate. Now, I'm not sure if it's because of the budget situation and perhaps a desire to reduce costs for a bill, or a misunderstanding about intent versus statutory language. But I think those involved in the California legislature and its legislative process should be aware of the difference. In the 2024 legislative session, there are a growing number of instances in California bills and ultimately statutes where we can find statements of intent by the legislature, of course. Now, while there's nothing inherently problematic about intent statements, in fact, they can be quite helpful in cases of statutory construction when a statute is ambiguous. But they do not equate to a statutory requirement or mandate. In other words, intent statements do not equate to mandatory or binding language. As intent statements, they cannot be a substitute for requiring an act by statute. Now, while broad statements of intent are most appropriate, at least in my opinion, for giving interpretation guidance to the courts and executive branch agencies and departments, for specific statements of intent, I think they need to be turned into mandatory or permissive statutory language. Otherwise, intent language is simply not binding. It's only an opinion, and intent statements don't have any authority of law. For example, a recent California appellate court decision stated legislative findings and statements of purpose in a statute's preamble can be illuminating if a statute is ambiguous. But a preamble is not binding in the interpretation of the statute. Moreover, the preamble may not overturn the statute's language, obviously. We know that statutes in this state use the term or word shall to be mandatory and the word may to be permissive. Now, when the legislature has a specific intent statement, why not turn that statement into a mandatory or permissive one so that it's actually binding rather than merely a statement of intent? So here's a quick example from a recent bill and how it will be a mandatory provision of law rather than an intent statement. They strike out the beginning. It is the intent of the legislature that the department, in establishing a system pursuant to this section, maximize the use of available federal funds. Instead, they strike it's the intent of the legislature and they add two words, the and shall. So now it would read, the department in establishing a system pursuant to this section shall maximize the use of available federal funds. I appreciate the proposed language change in existing law because it turns a simple statement of legislative intent that did not have any force or effective law into a requirement that the specified State Department actually do something. Otherwise, the intent statement had no effect to it. It simply stated the intent of the legislature that the department would hopefully do something in the future. This bill amended that unenforceable language and instead directs the department that they have to establish the specified system. Now, again, California courts, I think, have been clear in the distinction between intent and statutory language. For example, the Supreme Court said, in considering the purpose of legislation, statements of the intent of the enacting body contained in a preamble, while not conclusive, are entitled to consideration. Although such statements in an uncodified section do not confer power, determine rights, or enlarge the scope of a measure, they properly may be utilized as an aid in construing a statute. And last year, in a more recent California Supreme Court decision, the High Court said, as explained above, we view the legislature's uncodified language not as imposing a standard or condition for discovery or admission, but as an interpretive aid in construing the statutory scheme. As a result, if the legislature wants something to have the force and effect of law, it can't rely on mere intent language to accomplish that goal. Instead, the legislature has to use affirmative statutory language in order to create a mandate. Otherwise, it'll just be wishful thinking by the legislative branch of our state government.